So, along with this email, you've received copies of your estate planning documents, and the primary estate planning tool in your plan is a last will and testament. So, when we have a last will and testament, we're going to talk about practicalities and coordinating your assets with your estate plan a little bit later in this process. But typically, the last will and testament is going to serve as more of a fallback for financial assets as long as we've beneficiary designated things where we want to. But estate or last will and testament still serving as the estate distribution tool. So I want to talk about the structure of this document and make sure that everything is lining up with your wishes. So if you're looking at this document, the first section you're going to come to is Article 1. That's the family information, just confirming that we've got everybody listed there how you would like to see them. This is going to lay out definitions, so if your document uses terms like my husband or my wife, this is going to define who that person is, or my children. Those individuals are going to be listed there. If you were not to be including certain people in your plan, this information should be here as well. Moving into Article 2, this can be called a couple different things. So Article 2, if you're doing some specific distributions, is going to be called specific distributions in tangible personal property. So if you've said, I want to leave $5,000 to this individual, this is where you're going to see that type of language reflected. If you said, I wanted to leave this bequest to this charity, that information is going to be in this section as well. It's also going to deal with tangible personal property. Some folks like to specifically designate where things are going to go. Other people say, you know what, my executor can handle this. So a lot of times you're going to see language in here that just refers to a tangible personal property memorandum. This is where you can use an outside document to just give guidance to your executor and say, this person gets this item, this person gets this item from my estate. So Article 2 lays out those types of wishes, specific distributions, and tangible personal property. Article 3 is where the bulk of the estate planning takes place. So this is your residuary distribution. So if you've said my spouse is my primary beneficiary, your residuary distribution is going to be everything to my spouse. It's going to have the fallback to that as well. So if your spouse has predeceased you, the language here is going to, if you've said I want everything to go to my children, after that it's going to say everything to my children. If you've put any stipulations on that, like it needs to be held in trust until the age of 25, that information is going to be here as well. Otherwise, it's going to detail that your children are going to receive everything outright. After that, after Article 3, you're going to go to the remote contingent distribution. And this is a scenario where everybody else that we've named in your estate plan has passed away. And this is where you've detailed your wishes on what should happen then. So you could, you may have named certain individuals to receive your estate. You may have named certain charities to receive items from your estate, or dollar amounts or whatever we've discussed in a meeting. But the remote contingent distribution only kicks in if Article 3, there's no one there to receive anything. After that, Article 5, this is where we've detailed who's going to step in and serve as your executor. So this is the person going through the motions with the clerk of court, carrying out the overall administration of your estate. And if we've named trustees under your plan, this is where we've done that as well. After Article 5, we turn to Article 6. If we've got trust powers, those are going to be included there. But overall, from here on out, it's just powers that we want your executor to have or your trustee to have in the administration of your assets. Document gets purposefully long. We want to make sure that your executor and trustee are empowered by this document and not just relying on statutory language to be able to step in and administer your estate. We encourage you to ask any questions about this part of the document. If there are questions about any certain terms, please ask the attorney at your review meeting. Otherwise, we look forward to seeing you very soon. Thanks.